Oh, thank you. Live.
Welcome, everyone, back to the House Committee on General and Housing. It's still Tuesday and it's still April 14th. So we're going to talk for a little bit about S-230, which is the omnibus labor bill from the Senate. And just by way of background, it was suggested to us on Friday by members of the House Commerce Committee that we consider putting in S-230 a much narrowed version of their bill on non-compete. If you remember, just by way of background, we have a non-compete bill on our wall. They had a non-compete bill in their committee, which was actually, I think, Marcotte's bill. And so I talked to Marcotte, and basically when I talked to you guys about it, we just gave the issue to them. And they heard it ad infinitum and developed a lengthy, complicated bill, which then ran into trouble over coverage of a related issue, labor issue, and the labor unions. And so it basically, they couldn't resolve that issue, and just the whole thing kind of collapsed. It didn't make it to the floor. And I thought that it was an interesting bill and regretted. Remember, we took a little testimony on the whole problem of non-competes, particularly as they apply to, apparently, which are often applied to segments of the workforce where it's kind of oppressive and it doesn't really serve a useful purpose. So they suggested that we think about putting in Act 230. And our witnesses today are describing and addressing that issue. And we'll probably have more witnesses later in the week if this is going to go anywhere. But at this point, we are not actually proposing to insert this into S-230. We've got some language which our council have prepared, and we're looking at it and exploring it. It's all that's happening. You have anything you want to add?
Me?
Yeah.
I think you summarized it quite well. We're just having a conversation and hearing more background and see it, how things go.
Right. I've made it clear to all the parties
We
that
have the time.
we have the time to hear this. We don't have the time for a replay of the entire complicated disagreement that emerged the
Rather
last time
not.
around. And so if there's a way to pass a more constrained version that people are happy with, we'll consider it. So let's start with Sophie.
Good afternoon, Sophie Vidatni for the Office of Legislative Counsel. If I go ahead and share my screen.
Of course, that's what we expect.
I'm just going to do a very quick, I love colored charts here. So just as a quick reminder for folks, what's in S-230. So S-230 has a number of different things in it. The first three came over from the Senate side, and then you added in Section 3A, which was H556. And so those we've gone through before, and then what we're looking at today is this new Section 3B, which is adding in a portion of H205, prohibiting non-compete agreements for non-exempt employees.
Which were, again, Sophie, for form's sake, has put it in the bill since that's what we're talking about, but we haven't anywhere near got to that point yet. So go ahead, please.
Version 4. Okay. Version 4.1 of S-230, and I'm just going to fast forward to the new section that we're talking about. So this would add a new provision into the Fair Employment Practices Act, And it simply provides that agreements not to compete between an employer and a non-exempt employee as defined under the Fair Labor Standards Act are prohibited as presumptively coercive and a restraint on trade unless bargained for as part of a collective bargaining agreement. So if, for example, there's a collective bargaining agreement out there that for whatever reason happens to contain some language around non-competes, then would not interfere with that. But generally speaking, this would prohibit agreements not to compete with non-exempt employees. And I've got a little chart on non-exempt employees, which I'll go through in a moment. But generally speaking, with non-exempt employees, you're talking about those employees that are sort of most marginalized, the ones that are paid the least, hourly workers, and who not really in a position to make autonomous decisions in their jobs, etc. So these tend to be some of the more vulnerable employees in terms of non-compete agreements, and why some of the worst abuses come up is with your non-exempt workers, and there's stories out there nationally around, subway shops and, prohibiting people from going to work elsewhere. So this would cover those kinds of situations. And then it has subsection B is really just the remedies piece. So if an employee challenges the non-compete agreement, they can't be retaliated against for exercising their rights under the section. And the penalty provisions that are currently in the Fair Employment Practices Act would apply. This is pretty standard language throughout the Fair Employment Practices Act. So that is very briefly what it involves. I'm just going to run through exempt versus non-exempt. So, and again, there are always some nuance to it, but generally non-exempt employees are hourly. You can be non-exempt and be salaried, but that's unusual, and the employer still has the obligation to make sure that the minimum wage and overtime rules apply. So if you're non-exempt, you're entitled to receive overtime 40 hours or more. And again, if you're salaried, typically you don't. So again, if you only work 4 days in a week, you would still receive your full salary for that week. If you work 60 hours that week, you still receive your full salary that week. You don't receive anything additional. And then as far as salary goes, the current federal minimum wage is $7.25 an hour since 2009. The state minimum wage is $14.42. That typically goes up each year. And then there is, to be considered exempt, there are actually two tests. So one is a salary threshold test and one is a duties test. So the salary requirement is that you have to earn at least $684 a week. So if you are salaried but you make less than that, then you would be considered non-exempt. And then the duties test, and again, there's a whole array of how you look at this, but essentially your duties have to require advanced knowledge or skills, and you have the authority and ability to make independent decisions. And so like if you're a supervisor, you need to be supervising 2 or more employees to qualify as exempt. So there are different rules around that. And then typically for a non-exempt position, you're just doing the job, you're told these are the tasks you need to do, and you do those tasks. You don't have a lot of independent discretion around how you do your job. Supervision, typically for non-exempt, they're typically directly supervised. And if you're an exempt employee, typically you would receive little to no direct supervision. And then just some examples: construction and maintenance, non-supervisory, retail workers, clerical, secretarial, as compared to employees such as doctors, lawyers, teachers, business executives. And again, there are different fact sheets that go through for each of the different categories of exempt employees. So that is a very quick.
Questions by members of the committee. Sophie, could you put it back up though, because on the text. And questions of Sophie? I have a couple of questions, Sophie.
Okay.
What does it mean to say presumptively coercive? Does that mean that one would have a chance if a non-compete is challenged to argue that it wasn't coercive?
So the current prohibition would effectively prohibit agreements not to compete with non-exempt employees. And the reason that they would be prohibited is because they are presumptively coercive.
Under that act. Fair Labor Standards Act.
The Fair Labor Standards Act doesn't address agreements not to compete. The reference to the Fair Labor Standards Act is around what the definition of a non-exempt employee is.
So is presumptively coercive and a restraint on trade are those terms of art that are recognized in the labor law.
Yeah, generally speaking, when you're talking about agreements not to compete, so you're usually looking at things like, if someone has an agreement not to compete, what's the length of time that that agreement not to compete applies? Is there a geographic limitation? Is there a scope of activity? And again, it varies depending on the situation. If you're doing something very unique and unusual, for example, for a startup, the geographic area could be the whole of the United States, or it could be the whole of the world. If you're doing something sort of more regular and routine, it might be a 10-mile radius or a 15-mile radius. So it really depends. They're all, a court would look at the different factors and then weigh them. It would be very fact specific as to a particular agreement not to compete and how restrictive that was and how appropriate and reasonable.
But here, it wouldn't be subject to some extensive factual inquiry.
Right.
It's just essentially a flat prohibition for this narrow class of non-exempt employees. I take it someone like a hairdresser, it would depend if they were employed if they're employees, they could be non-exempt.
So, right, if they're
Depends on
typically
their
paid by
hours.
the
The
hour,
hour.
then they would be, right, they would be
Non-exempt.
non-exempt.
But if they're sharing space and they're contractors, so they're just an independent contractor, they wouldn't be
They're a
covered by
co-owner or something.
Right, they wouldn't be covered by this. I guess my last question is, we're not familiar, since we handed it off, with the larger bill. Can you put this in my understanding is that what we were attempting with this situation was to see whether a much narrowed version or much more specific version of a broader bill could be feasibly inserted in S-230 in a way that would not cause a replay of all the controversy that existed before. Can you assist us by putting this in the context of 205 and what else was covered?
Yeah, so 205 had some extensive definitions in it around what is an agreement not to compete, what is not an agreement not to compete. So for example, it didn't cover things like non-solicitation agreements, trade secrets, non-disclosure agreements. And then it essentially prohibited agreements not to compete unless you met, there was a number of carve-outs. So things like if you were selling a business or you were dissolving a partnership or dissolving a limited liability company, those would be exceptions. I mean, that's not unusual if you have an owner of a business and, someone else is purchasing it to be like, well, you can't just go down the street and, open up the same business just down the street. So those things would have been permitted. And then there was a specific breakdown of when you could have an agreement not to compete. And that dealt with things like you had to have a salary that was 300% of state minimum wage, which I think is right around $90,000 a year. You had to have information that was material and would be, if you took that information somewhere else, it would present sort of a really inherent existential threat to wherever you took it to. And then it would still have to be reasonable in terms of the geography, the time, the scope of activity. So there were a number of factors that in order to have a valid agreement not to compete, you would have to meet those. There was a general broader prohibition beyond just non-exempt folks. It also included language around healthcare providers. So apparently this has been an issue in healthcare. Private equity comes in, acquires a practice, and then restricts the ability of people to open up a practice nearby. So there was language that was added in House Commerce and Development that had come from the Committee on Healthcare. And they had taken it out of the bill to put it into H205. So there was language on that. And then there was a separate, so that this would all have been under creating a new section under the Fair Employment Practices Act around agreements not to compete. And then it also included another section under the Fair Employment Practices Act dealing with what's called stale pay provisions and generally prohibiting stale pay provisions that are coercive. and require people to pay back, you know, if they receive training that the employer wants them to have and is essential to them in that job, but then the employer is like, right, but you need to pay us back if you leave. So there was language around stale pay provisions as well. So it did cover a lot. It covered a lot of ground. So this is a much narrower, very specific provision.
So, and were the stay or pay provisions also lengthy in that they had definitions and exemptions?
Yeah, not as much as the agreements not to compete, but it did have definitions. And again, there was discussion in House Commerce around what's included, what's not included. If you worked for a bank and had, through your employment, got a good deal on a loan, it didn't mean you didn't have to pay back your loan when you left. So there was, it tried to take into account all the different nuances that were brought up by witnesses in House Commerce.
Yes. Tom,
referred-
are you?
Oh,
Just remind me again, where that bill died?
It died on third reading. And the House floor, it passed in second reading, and it died on third reading. It got recommitted back to House Commerce and Economic Development.
I saw it. Okay.
Is
Ashley, I think
is
you had a question.
Ashley?
I'm relatively supportive. I think I have concerns with attaching this to exempt versus non-exempt. One of my biggest concerns is kind of the two-folded salary minimum. And so for those who followed the Fair Labor Standards Act, it's pretty notoriously always been pretty low. That threshold's been 35. And then in 2024, it bounced to 40, roughly 48.
48,000 a year? Okay.
And so what happened was a court in Florida or a southern state fought it. It was appealed, it kind of waffled. It was an election year, and so what ended up happening is it has since gone back to 35. My concern, as someone who deals with employee classification, is I'm not sure putting it on the exempt versus non-exempt, I don't really know if there's certainty in that, because that amount can change pretty willy-nilly. I don't want to say willy-nilly, but arbitrarily that amount can change, and then things are kind of thrown up in the air. I know for months when we were looking at this increase in change, that all of a sudden we're trying to make sure all of our employees are at the right amount. And I think it's when you're looking at duties, it's a lot easier to say, okay, well, I can classify this person because of this duty that makes them exempt versus non-exempt. But when we're attaching it to the salary, that's a lot harder to maneuver. And so I'm just I'm at this point just talking out loud. I think I just have some concerns that I'd want to talk through. But does that make sense?
Right. So, I mean, yeah, just to follow up on that. So the first Trump administration was actually the one that increased it to 35,000. There had been some effort, I think, under the Obama administration to move it up, but that actually happened during the Trump administration.
Yeah.
During the Biden administration, they had a two-pronged jump up.
Yeah.
And so that did put employers in a situation where someone may qualify on the duties test, but their salary now is no longer, it's going to be too high. And therefore that would make them non-exempt, and it would cause employees to have to be reclassified from being salaried or being exempt to being non-exempt. And that was a major headache for employers. So yeah, I mean, I understand the concern with that. I think the goal by tying it to non-exempt was intended to make it as simple as possible.
Absolutely. I think
Yeah. But it could, depending on what happens in the future, you could have another administration that wants to increase the salaries portion of the task. And what happened was with the Biden proposed increase was essentially I think it was the Fifth Circuit, but basically held that because the salary was going up so rapidly, it was essentially eliminating the duties test. It was essentially to becoming just a salary test. And that was the reason it was struck down, was because the salary was elevated so rapidly and so
Yeah.
high.
I think it was like
Kind
the
of lost the
largest
duties
increase, even from like back in 2010. It wasn't even quite that large. It was, and even the two-pronged, it was large.
I would say, just going back to what was in H205, there was a concern around salary for that in terms of, to the extent agreements not to compete were going to be permitted. There was a salary threshold for that, but again, the goal was not to put in a concrete amount.
Yeah.
Because then it gets stale over time. So that's why it was put in as 300% of the state minimum wage. So it would effectively move up
Okay.
as state minimum wage goes up. So
Okay,
that may be another way to think about this, is tying it, in some way to the salary. But I will say that got very complicated.
Yeah.
So I'm just putting it out there.
Yes, Tom, sure.
I'm looking at the language in line 19 and 20 here. Non-compete. Brings down to not be prohibited as presumptively prohibited and restrained on trade unless bargained for as part of a collective bargaining agreement. So if you're a small shop and you don't have a union, but it's written into their job agreement, does this require participation of the union? Because I'm just, my impression of collective bargaining agreement is that this is kind of an organized labor sort of thing. So what do you do with the small?
Right, so this would, the example there is, well, the exception there is for bargaining for as part of the collective bargaining agreement. I don't know how common that is for these types of workers that are not exempt. But it just, again, the goal was not to disrupt any existing collective bargaining agreements that may be in place. And one of the challenges with agreements not to compete is that uneven bargaining power between an employer and an employee. But if you have a union, the union is then negotiating on behalf of the employees. So it's less of a coercive sort of situation. Because presumably the union is negotiating, what's in the best interest of its employees. If you, as a small employer, had non-exempt employees, this would preclude you from having an agreement not to compete with them.
Be a problem for entrepreneurial startups that do have the new approach to any trade
Well, again, if
or
they,
technology. So
and again, there was a lot of conversation around startups in House Commerce and Economic Development. Typically those folks are salaried, they're just not salaried in a very high amount, and their job duties would almost certainly qualify them to be exempt.
Yeah.
So I think it would be quite unusual to have,
okay.
if someone's non-exempt, they're not likely to have the secret sauce for the entrepreneurial company. Startup.
Yes, go on.
The other day, let's just say the field of hairdressing. And they have non-compete sometimes, the esthetician field.
Mhm.
And then someone in the hall, when I was talking about it in the cafeteria, I guess it was the hall's cafeteria, was saying that's called something different. What's that called?
That's an independent contract. Well, it could be a non-hourly wage. It
No,
could
it
be.
was like, which, yeah, solicitation. What's the difference?
So non-solicitation would be that if you leave your position
Yeah.
with beauty salon A, you can't take the customer list from beauty salon A and
Yeah, like-
reach out to those customers and say, hey, I'm opening my own, beauty
Right.
salon B down the road. Come and join me there.
Mm.
So that's solicitation.
And then what, they get a cease and desist?
Right.
I think I've heard of
But
that.
that's
So
not,
that's
that's
different.
not.
That's not this.
That's not.
But so then the hair people and estheticians that I know, lots of them in my area, they don't get non-competes, those are likely non-solicitations.
Right, so you can't, you can't, again, take someone's customer
Well,
list.
what if they stole, like,
So-
the non-compete is different, cause then they'd be like taking the hair recipe. Sorry,
It'd have to be specified.
okay, yeah, I didn't look at the contract, so, but likely it's, she's just calling it that.
Right, I mean, and would effectively be, if you're leaving, you know, this beauty salon, it's like you cannot work or open your own beauty salon within a 30-mile radius for the next 2 years.
Yeah, I don't like
And then
that
you-
though, cause we're so
Right.
small.
Yeah, I know,
Right, but
that's
then
why
that's-
we're.
Right.
Right, and then you're sort of really restricting someone's ability.
Yeah,
to
I don't like
practice
that.
Well,
Debbie?
going off of what Emily's saying, I mean, if you're a hairdresser and you're working in a big place, you're renting your little booth and all that. And that, I shouldn't use the word little, you're renting your professional booth. And you decide, I can't work in this environment, I'm going to leave and maybe open my own place or whatever. But you could take your clients with
Your
you,
clients.
right?
I mean, you can let your clients know, again, if there's time to do that, you just can't, you can't be soliciting generally. And you can advertise, you can be like, you know, Debbie Dalton Salon, you know, is opening, and that way people that went to you in the previous place would be like, oh,
Okay.
looks like Debbie's.
Yeah.
I think in this day and age with the internet, you know, you don't.
Oh,
have
yeah,
to feel
Instagram.
confident that you can, right, you can probably find someone once they've left.
Sophie is, okay, I get that. 205 had a much broader reach. It wasn't as narrowly constrained in terms of just hourly, non-exempt employees. But can this function without definitions? In other words, it talks about an agreement not to compete, but it doesn't define it. Do we need to define it? Is it okay, do you think?
Well, again, that's a decision for the committee, like, once you start going down that path, you're gonna end up with a lot of definitions and discussion around it. I would say agreement not to compete does have a general understanding of what that is. There's certainly case law that talks about agreements not to compete, and again, you're really looking at the length of time, the geographic scope, and then the activity that you're
Right.
restricting. So I think there's a general understanding of what an agreement not to compete is.
Okay. Yes,
I'm gonna go back to my original question. I'm so sorry. It's just like stuck in my head. In this hypothetical situation, say I'm an employee, I make 34.
you want to put the table back on?
What? No, I don't need the table. It's fine.
No,
Oh,
okay.
God, no. I'm making 34,000. So I would be considered non-exempt. Something happens. I am now making 36. I'm 36, so I can now be considered exempt
If you meet the
if
duties.
the
test.
duties test. But then what happens if, again, the FSLA number changes? Like, can I go from, if I started and I couldn't do, like, what happens there? If I'm not eligible for a non-compete and then I am, or the other way around, where I started with a non-compete and then all of a sudden I'm not,
So,
like,
right, so now
what
you've gone,
happens?
so now you've gone back to being hourly, what happens to the agreement that you've already, the non-compete agreement you've already signed? That is an interesting question, I don't know what the answer to that would be.
I think that's what's just stuck in my head right now.
Because essentially it would then be prohibited.
Correct.
The question would be, but you already had signed that before, so you already have a pre-existing contract. So whether that,
Well, would it be?
It would be
But
void,
no,
don't you think it'd be
but I mean,
void?
when like when the minimum wage goes up,
But this isn't
the-
minimum wage.
no, I
It's
know, I'm
very
just saying,
I think. it
I mean,
would
your
be-
category,
The law preempts the contract.
yeah,
So don't you think probably it would be ruled that it was a valid contract until it wasn't? And then
It's what? What was that?
it was a valid contract until it wasn't, and now under current law, it's not.
That's why people lose their benefits all the time, is because suddenly they.
I mean, the law trumps sort of contract.
Good clip. What time are we?
Okay. Any other questions of Sophie at this point? We're gonna have to, I mean, it's not gonna be over today.
Well, I'm just curious what would be the pros and cons? Like, do we want to keep the person protected or do we want to make everybody play by the same rules?
I think that's a conversation for our committee to have. Like a policy.
It's a policy issue as opposed to her issue.
Right, but before we have that question, I guess we do have to really know whether the contract is trumped by the change in law.
Well, under that narrow circumstance, I think we're not gonna know, we wouldn't know the answer probably till someone litigated it.
You realize I'm supposed to be in hospital.
Okay. And we want to move to our next witness on this, which is Representative Abby Duke, who was involved in 205 in House Commerce and is a guest of our committee.
Here. Thanks, Sophie.
Thank you, Sophie. Welcome, Abby.
Thank you for having me.
Thank you for making the trek.
You know, I worked hard. I'm here to tell you the epic journey of H205. Okay, not Bill.
This doesn't count as competing when you come over to this committee to legislate, right?
I am here to be.
She's non-exempt in the worst way.
That's right. Yeah, right.
Yeah.
I am here to be as helpful as I can in this committee, so let me know how I can help. I can say just briefly as an intro, H205 started, we started taking testimony last spring. And then a kind of group formed, it was not a study committee, it was a group formed to look into the matter. That had a dozen or so people on it from a whole variety of different, interests, labor, business, chamber, whole bunch of folks got together and met, I think 6 times, 3 times. Austin. 6 times they met and wrote a letter. It's on our, you can really compiled research on the issue of non-compete agreements. It's the letters posted on our page, and it included an overview of what is case law in Vermont, what are issues that have come up, how are other states dealing with non-compete agreements. And so then we took all that information and incorporated it and really put a tremendous amount of time, took a lot of testimony, and really did our very best to balance competing interests, and found a path that until the final moment was really I thought it was a really good path that looked at the legitimate business reasons for having non-competes, as well as some really strong reasons for not having non-competes, because they do fundamentally impede the economic mobility of workers. That you even if you found another job, if you have a non-compete, you may not be able to take a job that you want to take. So I think allowing non-compete shouldn't really not be allowed in really legitimate time periods or for legitimate reasons. So what else can I tell you? You want me to tell you kind of our thought process about how H205 approach non-competes?
Well, I think one issue that we want is do you feel like this language, what's your reaction to this language? How does it stand the test of threading the needle between all the different sort of considerations?
Sure, thank you. So the way we approached it, and I'll say the way we approached H205, which I think we'll walk through the various considerations that go into it, and then I'll talk about the specific sort of narrow focus. So H205, we said, okay, there's a broad ban on non-competes, and then we're going to have exceptions. And as Sophie mentioned, number one, a non-compete is not a non-solicitation agreement. It's also not a non-disclosure agreement, which I think when you talk about a recipe, for example.
Yeah.
So, You know, a non-disclosure agreement would be like, you can't take a trade secret with you.
Right.
So that is still allowed.
That is. you
Secret
can-
recipes are still
Secret recipe is not non-compete.
kept. List of
non-solicitation.
customers
It's
kept.
not
Yeah.
non-compete. Non-compete is only,
I'm just trying to keep it into like what it
Yeah.
does do rather than what it does
Yeah.
not do.
a
So,
non,
so I'm just
a
saying,
non-compete just would say, a non-compete agreement would give, like, let's say you're working for me and I've got this non-compete. It would limit your ability to work for a competitor bound by time and space, basically. So within a certain geographic area for a certain amount of time, you can't go work for a competitor. That's basically what a non-compete agreement says. And case law has, you know, that's what it focuses on is time, scope, and geographic area. Okay, so that's what a non-compete is not. It is not non-solicitation, it's not trade agreement, and not trade secrets. And then the other exceptions we built into the bill were if you're selling a business or if you're dissolving a partnership, you can have that's an exception. And then we did a two-part test for all other jobs. One was salary, and we pegged it to 300% of the minimum wage, which is about $95,000, I think, something like that. And duties. So if you make over a certain amount of money and your job, I don't have the language in front of me, but basically your job is you have, you know, you are privy to really important information in the business, the processes, you maybe have relationships with key clients. So it's really a two-part test of what do you do at the business and also how much money do you make? And so we did not, now I will say, so that was how we structured it. And through testimony, I think the two most compelling places where there can be abuse with non-competes, or we have a real, I think, public interest in limiting non-competes are low-wage workers. So, and I do think that maybe with this language, we get to that. We get to it partly at least. I'm no expert on employee classification, but, you know, taking a look at what Sophie put together with the chart, it makes sense to me. But if you're a low-wage worker where you are leaving a job because you're going to make $5 more an hour, like there should be no scenario in which there can be a non-compete to keep you when you're just changing a job so you can make enough money to pay your rent, right? So I you know, I think that that gets to at least a potential like egregious abuse. How often are non-competes used for low-wage workers? I think not very often. I think hairdressers or estheticians is a field where sometimes it's used. But I don't think there's widespread abuse of this in Vermont. That said, I think it makes sense to make it very clear in statute that it is not allowed. Because, you know, what we heard testimony about is right now, you know, case law does, if you had a non-compete for a low-wage worker and you sued, you would most likely win because the case law says it should be bound, you know, it should be something that makes sense.
you're saying the worker would win,
Right,
Okay.
But they'd have to sue.
but they'd have to
but they'd
sue.
have to sue.
They'd
So
have to
it's like
sue.
seeking the remedy
Right.
is an expensive,
Right.
high obstacle.
Exactly, and the reality is they're not going to because of resources. So having that in statute saying at least, you know, we're gonna ban this really egregious overuse of non-competes makes sense. And then the other piece we heard testimony about, I do think there's compelling reason. Sorry, you weren't raising.
No.
And there's compelling reason to, you know, at least to consider. It has to do with healthcare providers. And, you know, that is a place that non-competes are used that limit. So if you're a nurse practitioner, for example, working in a clinic and you want to go work for another clinic, if you have a non-compete, then you may need to move. You may not be able to get a job in your profession, you know, within 20 miles.
So wait, those are happening, those kinds of,
Those
those
are happening.
Like, let's say I go to Evergreen Family Health.
no, I get the
No, I'm just
scenario,
thinking-
I
I'm just
understand.
thinking, like,
I'm
so
just
someone-
trying to gauge whether the policy
Oh, I was-
solution is coming out of
So,
this actually occurring or whether we're trying
Yeah.
to prevent it.
so we heard testimony from a woman who's a chiropractor in Hardwick, and she was working for a chiropractor working for a clinic in Hardwick. And it was not a good situation, and so she wanted to leave, but she had signed a non-compete agreement. And I think it was within 30 miles of Hardwick. Imagine 30 miles of Hardwick, right? And so she was not working as a chiropractor, she was doing something else for, 2 years, because she didn't want to move, and she also didn't want to commute, an hour and a half or whatever.
That wouldn't- It's, she was not a non-exempt
That's
employee,
right.
right? So
So-
this would not help them.
Right, that was just an example of the two most compelling pieces of the bill. I thought
I
were.
just wanna say, I wasn't actually trying to explain the scenario. I had a question about like an evergreen place, but
Yeah.
now I forgot it.
Oh, okay.
So, but back to your original question, I mean, I do think this very narrow focus gets to, it seems to me a benefit to have in statute something to make it very clear that it is not allowed.
Did you define the healthcare worker situation? How did you define that?
We talked about them as healthcare providers. So it was a provider with a patient, direct patient relationship.
And those provide, I assume that it wouldn't simply be as simple as a non-exempt employee or a healthcare provider.
Yeah,
Because you had definitions, exceptions,
yeah.
Right.
I'll pull up that.
And does that include like mental health, like licensed social workers and psychiatrists and like Otter Creek bigger practices, like, I don't know.
Yeah, no, it's a good question. I'll pull up that language and I can also check in with Sophie about that.
Okay, I'm gonna ask you one more question, which is, you'll forgive me, a little difficult.
No, I was just playing with my pen.
Okay, so my question, which you can of course decline to answer, is, so what happened in the end, in your own words,
Yeah,
and why wouldn't it happen with this?
okay. So what happened was there is, we put a line in the bill that said, this, as one of the exceptions to non-compete agreements, was, teacher contracts. Teacher contracts were exempt. So,
You could, the teacher contracts were exempt from the prohibition.
You can compete, you could not compete if you were a teacher.
so meaning, wait, this bill does not apply, I'm sorry, I'm not accepting. This bill does not apply to teacher contracts. So it basically said, we are not saying anything about non-compete agreements with teachers, related to teacher contracts.
Right.
Because, Sophie, our ledge counsel, said, this will keep us from conflicting with some statute in the statute about teacher contracts. And that statute related to teacher contracts says, and you can go to going off memory here, but basically says that if you are a teacher and you you cancel your contract, you cannot work in any other public school in Vermont for the year. Now,
Trying to prevent.
I wanna be
somebody
clear,
leaving
I
in the
don't-
middle of the-
I think that needs to be discussed, not in here, but in a future legislature
So,
time.
Yeah, okay.
the problem, ultimately, I'll just boil it down, because I could talk for a long time about the nuances of this. Basically, what it comes down to is the ability for teachers to get out of their contracts should be in their contracts. It should be in the collective bargaining agreement. The problem is, it's not in their collective bargaining agreement, it's in statute. But how do you take it out of statute if it's not in collective bargaining agreement? It's like a egg before the chicken or the egg kind of a thing, right? So we have some groups saying we need to, in the amendment that ultimately killed this bill, deleted that statute. And so, but if you delete that statute, and then it should be in the collective bargaining agreements, but it's not there, how do you negotiate it in, right? So one party would say, well, I can't negotiate it. I'm disadvantaged because I need to negotiate it in if you've removed it from the statute. And the other party says, well, am I making sense?
Yeah.
So
Well,
that
yeah.
was
What's
basically,
the other party say?
So the school districts,
okay,
the employers would feel like, why would I add this?
right. exactly.
If-
School districts
if
say,
now
"It's
I'm not
working."
forced to do it.
Right. Why would I add this to the collective bargaining agreements? And and they say, and you put me at an advantage, if you delete this statute before it's in the collective bargaining agreements, I'm at a disadvantage. And the teachers say, well, if you say this statute doesn't apply if it's in the collective bargaining agreements, they say, well, why would then I'm at a disadvantage to get it into that. So the problem is it should not be in statute, but the parties can't agree about how to get it into the collective bargaining agreements in a way that doesn't disadvantage one party. Is that clear as mud?
And I just,
Yeah.
Um,
How frequently are teacher contracts negotiated?
3 years.
Okay, so if we simply added a sunset date to the statute, it's 5 years out. They
Well,
know it's coming and they're all gonna have.
Was that discussed?
Negotiations with that,
that was discussed. There were a number of things discussed. So I'm not gonna speak for why, a number of options were put out there. One including sunsetting the statute, giving time for it to come to the collective bargaining agreements, including some language saying, as soon as it's in the collective bargaining agreement, the statute goes away. For unknown reasons, to me, exactly, an agreement was not able to be done. Yeah.
So,
And here we are.
So really other than that, I will say, I felt like the bill was we worked really hard to balance competing interests and really there was a lot of agreement that people, including folks who wanted the ability to have at times non-compete agreements, really were in agreement that we need to have the right kind of parameters. So it was really this sticky issue that has been an issue for decades with a 65-year-old statute that shouldn't be there. Every other state in New England has the ability to get out of your contract in the collective bargaining agreement. That's the way it is done throughout New England. And there's no reason, the only reason it's not there is because it's in statute, right? And the wording in statute is vague. It's not even clear exactly how it works in statute. So then it's the way it's interpreted.
yes,
What did you mean by the statute goes away?
Well, meaning if we were to, let's say we were to repeal that piece of the statute.
Okay.
That's what I mean. It's like, like, how does one, that's what I mean.
Okay.
So, because deleting that, like, should that statute be deleted? I think it should. But you can't just delete it without taking into account the real world implications for the collective bargaining agreements.
okay, so the parties were not able to reach agreement on.
Part, yeah. That is the sum is, it was that very specific narrow issue is how do non-competes apply or not apply to teacher contracts?
Is the theory behind this amendment the alleged Teflon, the hoped for Teflon of this amendment would be that somehow non-exempt employees aren't teachers?
Yeah, sure.
Yeah, and also that, yes, that non-exempt employees are not teachers, right? And those, and also and it also does not apply to collective bargaining agreements. So if there are, and the only thing we know of in statute that could be, some people could interpret as a non-compete agreement or non-compete sort of provision in statute relates to teachers.
Any other questions of Abby? Yes,
Teachers didn't include higher ed.
So this is specifically
K to
public
12.
school. Specifically, the
Public
statute
school.
specifically references public school teachers in Vermont.
So I don't know if this will help you. The FSLA, there is an exemption to the FSLA for educational higher ed, private school teachers. There is an exemption. They would be covered under that.
They're already allowed to compete, in other words.
No, this has nothing to,
Oh.
just like if we're talking about the language of this amendment and talking about exempt versus not exempt, just there's already.
any other questions of Abby at this time? I believe, I mean, without knowing for sure, I suspect that labor is busy trying to think about this. And we will have witnesses in and may want you back, so we'll let you know.
Just let me know. I'm
Yeah, you're
Very
nearby,
close.
yes.
very close by.
Thank you so much.
Yeah, you're welcome. Thanks for having me.
Very helpful, actually.
Thank you.
Austin? Come on up.
All right. Good afternoon, folks.
We knew you were a player in this, so we couldn't help ourselves.
I thought you were just gonna.
I think you've identified, Austin Davis, player and director of government affairs at the Lake Champlain Chamber. I'm gonna just back up for a second, level set. A non-compete agreement is a legal contract or clause where an employee agrees not to enter into competition with their employer for a specific period of time and within a specific geographic area after employment ends. In most states, including Vermont, a non-compete is enforceable if it's considered reasonable by the courts. And they generally look at the duration that you're not allowed to compete after you leave employment. In this state, 1 year is generally, if I were to kind of look at the case law, that's generally what's reasonable. You get beyond that, seen as unreasonable. You get below that, you're very reasonable. Geography, that can vary, but it has to be reasonable depending on what the work is. So if you're competing at a global scale, like we have employers here that are competing with, Amazon and Sony and Microsoft, they might have a very broad geographic scope on it. We might have folks that have just a matter of a few miles for their scope of it. And again, that's all based off our rich body of case law. And then there's the scope of work, what are they actually doing? But I think it's worth it at this point to kind of like zoom out and just unwind. I feel like there's a little bit of just kind of implicit bias in conversation up to this point around this. These are not about strictly protecting one entity or the other. They're about balancing protections for the employee and the employer. And when we think about balancing protections and we think about the protections of the employer, it's also worth noting that you're protecting all of the other employees that the employer works with. Because if I am working in a startup in South Burlington and I have a crucial amount of insight into this company and we're using first mover advantage as a cutting edge startup, and I want to leave and go to a very well-money competitor who wants to do what we're doing in this very little state, I can basically just make that startup superfluous. And I can ruin the lives of every other employee at that employer. There's an ethical component to these things that I think has been lost up until this point of conversation. And I think, a great example of the ethical component of this is the very own ethics agreement that you folks all are under as legislators. It's not technically a non-compete agreement, but it tracks exactly like a non-compete agreement. You folks are all prohibited from lobbying within the state of Vermont for 1 year after the completion of your term as a legislator. That's, a prescribed and reasonable duration, geography, and scope of work. They're not saying you can't work in Vermont at all. They're saying you can't lobby in Vermont. They're not saying you can't lobby in Massachusetts or Maine if for some reason that works for you. They're just saying here where you have an ethical duty and you could sell out your colleagues or utilize things that are not on the up and up, can't work here. And then for 1 year, it's just 1 year of your life that you can't do that. After 1 year, you can come here and you can lobby all you want. So I think that's, just kind of some of the level setting I want to do. So from there, I have just like 6 points to make and then about 3 questions. So one, I just said I'm pretty lonely here today. I was with a lot of folks in the company of many folks up until this point. I've worked on this bill since 2018, not this bill particularly, but this subject matter since 2018. It's a very weedy, very difficult one with no easy answers. And because of that, and part of the reason of that is that non-compete agreements are really about interstitium. I don't know if folks are familiar with the term interstitium, but it's kind of like the connective tissue and whateverness that goes between organs and cells and whatever else in the body. There's trade secrets, yes, there's non-disclosures, yes, there's non-solicitation, but really kind of what connects and what's in between all those gray areas, all those places you might not have thought of is non-compete agreement. So it's been a very difficult road. And over the last, 8 years working on this, there have been many folks involved in this conversation. Just recently, after the last legislative session, about a dozen at max, not everyone participated regularly, but about a dozen folks were kind of asked to engage on this in a working group over the summer and fall. And we brought, as Representative Duke said, a letter to the committee on commerce and economic development, outlining some of our ubiquitously held points and some of our agreement, some of the things we couldn't make headway on. But I just would point out that, I'm just one person. There's many folks that have been involved with this. I frankly think if you're starting, you almost have to start with all of them. You can't really leave any of them out. I'd also say frustratingly, the folks who are come to an impasse at the 11th hour and have made this bill go back to committee were not involved in any of this for the entirety of the time I've been working on this particular issue. I've never actually engaged or had any interest from the education committee until this particular session on this legislation. So it personally is a little bit frustrating, though I understand, where they want to be involved. You're not at the table, you're on the menu, but they have not been involved. And from my perspective, actually, the bill as drafted coming out of committee could have just kept the language that it had, and it would have kept the status quo. Is really the following the preceding floor amendment that asked the question and created the impasse. So number two, thanks for bearing with me. This has happened overnight. We've really worked on this thoughtfully. Some of the language that your leg council actually attributed to the House Healthcare Committee did not, in fact, come from the House Healthcare Committee. It came from our working group this summer. We all kind of agreed in these instances around healthcare, this language is appropriate. I think we all were, kind of did agree that we needed some kind of income-based threshold, and that clear modern metric to set the rules of the road. There's pretty ubiquitous agreement that we don't want low-wage employees using these. The issue is, where does that low wage start, and how do you understand, in context of, say, startups or places where employers want to bring employees into decision-making in a really, progressive way, like how do you ensure, that individual is not at a level of, salary, but like maybe aspirational climbing, that they can still get access to all that information. I think this 205, it represented an outcome that didn't make everyone happy, but despite that, I think everyone thought that it was worth passing and was the best that we've seen in all of these years of conversations. I think, what you have in this amendment before you has been tossed around numerous times and tossed out just as many times. I think, it doesn't necessarily strike the balance that folks were looking at. That leads me to point 3, which is, these things need to be applied judiciously. Vermont's current reasonable status standard has been shown to not be a problem. It's working well. We have rich case law behind us. One thing we've said in the past is, a great place to go would be maybe just codified case law, because what we hear when we say we have rich case law behind these agreements is, well, people can't read that case law. And we say, well, then maybe we just start this year with just codifying the case law so everyone can see it in the green books. But, these are really, because they focus on that kind of unique connective tissue between different aspects of business, and they are trying to balance the interests and needs of all these different people. These agreements are really complex, so you lose a lot when you try to handle them in statute. The really best not legislated, but almost litigated, or having someone look at them and judge them on the totality of all the circumstances and criteria. So we haven't seen an issue in the state. I think, as Representative Duke kind of pointed out, we haven't really gotten that many issues of we haven't seen issues of these being abused necessarily. We've seen examples of there's, if you Google examples of fast food chains and other states using these, we've not been able to find. We've asked ad nauseum for such examples of abuse and raison d'etre for this legislation, and we've not gotten that in the past. So we're purely working on hypothetical threats. And now we kind of get to this FLSA design, which I think is really potentially the wrong tool. It's using apples to oranges potentially. And I think, the FLSA was designed in the 30s to deal with overtime and labor expectation. I don't think it was intended to necessarily do this. There's a potential Venn diagram problem here where it doesn't neatly line up. I don't think everyone who is non-exempt necessarily should be left out of this, and then not everyone who is exempt should be using one of these. So you kind of have a problem here where you're tugging on like a spaghetti chart that is the Fair Labor Standards Act, and when you tug spaghetti across the table, it's not a clean drag across the table. It gets messy. So it'd be better to maybe not tie directly to that language and that statute. All of that said, I might have seemed sort of negative on this. I'm not ready to completely pass judgment on this at this moment. I mean, I got word of this on Monday. I got language this morning. I batted it around in my email with a couple of employment attorneys. I have had a little bit of time with all my free time today to think through some of the consequences of this, but I don't think I'm ready to necessarily say yea or nay as I sit in this chair before you. What I would say is, I would ask, are you trying to do just something? Are we trying to say, like, after years of going through this, we want to just get something? One thing I would say is maybe then just drop all of the extraneous language around the Fair Labor Standards Act and just start this year with just a wage threshold, and maybe look at the overtime wage threshold as a very clean, neat, tidy, not cross-referencing back to Fair Labor Standards Act, but just that number purely, and just do that. That will
Explain more. Don't assume everybody understands that.
So as you heard a couple folks talk about today, that there is a particular wage threshold by which, overtime compensation kicks in. If you would like to just do a clean, neat, amendment this year that I think no one would push back upon and doesn't get into any of the other extraneous conflict that's been around this, the easiest thing would just be to target that number. I'd say target that
This
number.
is the number, the salary number at which point
To trigger.
overtime kicks in.
Yeah. So that was 35,636 years ago. I think it went up to, what was it we said earlier?
35.
Brain's not firing all cylinders, but no one in the people who I've engaged with over the course of all of my discussion this has any issue with people below that number not being able to get these agreements. Folks are focused on people above those agreements. And I think for the most part, a lot of the constituency that I have and I've engaged with and other stakeholders, like they're even fine with a higher number than that, but they do have also the understanding that there are people who are in a situation where their salaries are quite low, but it's because they're at the ground floor of something new. If you're working at a startup out of, Burlington South End, you might be making 35,000 a year. You're there on a mission from God. You've got the special sauce, and you want to, start this company. Your salary will be quadruple that within a couple of years, but for right now. And the worry at that point is, if you prohibit non-compete agreements from this person, they could lose the first mover advantage. If there's four of us and we've all agreed we're gonna work on this project and we all know, and sometimes a lot of people think like, oh, it's a special sauce. Like that's trade secrets, but non-competes are there because sometimes it's not the special sauce, it's all the ways not to make the special sauce.
Right.
Which are also valuable. It's all the doors not to knock on for financing. It's all these other things. And that kind of knowledge, combined with first mover advantage, like if I want to just go to Amazon and say, hey, look, I think this little Vermont startup and they're doing fantastic work on X, Y, and Z, moving a little slow. If I had your resources, we can move right away on this, that's a very real threat for a lot of our entrepreneurs. So that's where the salary threshold, like what prohibits a lot of us from allowing it to wanting it to go higher, in a nutshell. But all this is to say, like, I think the threshold that you identified with the Fair Labor Standards Act, I don't think you find anyone who would say, we want non-competes below that threshold. You're not gonna find anyone. I think the only place where people kind of start to get some heartburn around that statute is when we have all the situation, as I said, there's some people who would trigger that non-exempt status, but should be covered by this, but for that, and then vice versa, and so.
Leonora, and do I have first Leonora?
Okay, thanks. I think we did at the same time.
Okay.
So I'm just hearing, I just want to voice, like what I'm hearing a lot for the, this can get, these non-compete protections could be maybe not beneficial for the public good, may not be for the public good when we're talking about the interests of a small startup losing employees to a big company that you can't compete with. Was there an effort to put, say, that scenario into statute instead of getting rid of all of the protections that we think could benefit a lot of people
Well, I mean, that's just one example.
without hurting a company?
This is where like it gets very, it's very specific. And that's where I kind of say like, they really need, these are things that are not really well legislated. Like you really do need a judicial officer to preside over the entirety of the circumstances and criteria. Because there's so many other things at stake. And like I said, there's also that just broader kind of ethical considerations that, I think we all want to, like, we don't talk about often in this, but like are obviously important to the legislature. They've created an agreement not to compete, not in name, but in practice for each of you, because they worry about abuse of knowledge that you have. So it's like, why would you not extend that same protections to your constituents that you thought were important, in the context of retiring legislators? So it's not an easy, there's no easy answer. And that's why I think like we've gone over this for 8 years. I think that honestly, from my perspective.
Well, I'm sorry, can I respond to that?
Yeah.
I think the reason for doing, and you're not allowed to lobby, isn't because you're going to compete with the legislature, it's because you're going to undermine democracy.
And I think
It's different than just like,
I think
building
that's
a
my
business
point.
or-
Yeah, I think like you're gonna undermine a local Vermont business potentially by leaving with the trusted information. I mean, like, if you think about a family business, if you think about someone who's brought someone into the fold to, show everything to them, and they're trusting that person to not, exploit that trust. And there's the trust but verify, and that's a non-compete. It's, I'm trusting you to come into the fold and understand everything about my generational family business. But like, I also want to put some, guardrails on this to make sure that like that trust doesn't get violated. And ironically, actually, I say this as someone whose family's in the case law. Boys Orthopedic versus Levine is my family business in 1987, I believe. It established some of the reasonableness doctrine and blue penciling for the state.
Emily?
Yes, for the sake of time, I was wondering, I know I don't want to give you extra work, but you seem invested. Wondering, if you would be willing and able at some point to help us out as a committee and write up what you had said would be kind of the benign approach, just so we can look at that and then, like, I didn't write it down.
The benign
Codifying the
approach
state
is just
benign.
find a wage threshold.
Yeah.
that-
So someone here besides
Right,
me
yeah.
wrote that
I wrote it
down.
down.
I think you identified as a group that you like the FLSA
Well,
overtime wage threshold.
Just, I don't think
We're
we've
just-
decided what we
We're
like.
just kind of, but
But I think the overtime,
I respect your opinion and expertise in this matter. And so I would like to weigh your recommendation, if you will. I know you didn't say you have a formal, but that would be helpful to see what your floor is, or ceiling rather.
the overtime wage threshold sounds like that
Not
was
over-
one where you felt
Overtime.
good. The overtime wage threshold is the salary amount at which point overtime kicks in. And he's saying he can't think of any group that would oppose that. And I guess I would like to refine what was just suggested and say, give it 24 hours of thought and give us some language. I do want to know just back to your Venn diagram. Who might be included in the FSLA language and excluded from the wage threshold, or vice versa?
Well, the wage threshold's kind of, very clean. That's a 1 gate test. So,
Right.
You're below it. You don't have to worry about one of these agreements. When you start looking at
You
FLSA,
got all these.
then you got all these criteria, and
Okay.
that's where it gets messy
I
too,
got it.
because,
Okay.
I might go through 1 gate, but not through another, and, you look at things like Fair Labor Standards Act looks at number of subordinates.
Yeah.
Like, well, if you're a Vermont small business, like, you might not have any subordinate, but you are definitely a C-suite employee who is exempt, like, there's all, and that just gets complicated. And that's why you folks also, not so much in this biennium, but like in past bienniums, talked ad nauseam about like misclassification, because it gets really complicated. So I'd rather not get into
Okay.
that weeds.
I understand that responsive. Ashley?
I was just gonna give educators
Please.
is a perfect example of the Venn diagram.
Yeah.
Is an FSLA, they are considered exempt. But we all know that our educators don't always make the best salaries out there. So there are a lot of nuanced examples and exemptions made in the FSLA.
Right.
That, and the duties also make it really difficult. So you could have somebody who's like a graphic designer, who that's very creative, and because that's a creative art, they could be exempt while also making like pennies.
Any other questions of Austin? Austin, thank you very much.
We haven't seen you in a while.
No, I've been a little preoccupied.
Yeah, the babies.
Yeah. Thank you.
Thank you.
So we are now, just for members of the committee and the public, but I think a next step will be on this. We're just considering it. We're gonna talk to council again and hear from a few more witnesses, probably tomorrow or the next day, tomorrow afternoon. And so in the morning, we're gonna be doing our field trip. And while I'm on the air, tomorrow the committee is going to go to Huntington Homes and meeting at 9:30 at Huntington Homes as a field trip, an exploratory field trip. So now we're going to go back to 328, and we have council with us with the latest markup of 328. Cameron, you want to join us? This is draft.
What are we at? Oh, it's not that many. Does need.
This is draft 1.2.
Does everyone have a good draft or need a copy?
We all have draft 2.1.
Do you have people?
Yes, we just got it.
Miriam's on top of it.
Miriam is totally.
Tuesdays.
Draft master.
Up and.
All right. For the record, Cameron Wood, Office of Legislative Counsel. I made the mistake of working and not logging into the Zoom while I was sitting on the sidelines. So give me a second while I pull that up. But happy to walk through draft number 2.1 of your amendment to S328. Before I share my screen and we get started, I'll just comment that the changes from the last version are highlighted in yellow. We have a few tweaks, and then there is the addition of a new section at the end. I'm coming into the Zoom, and then I'll share my screen.
Anyone gonna hit up free cone day?
What you say?
Is there a Ben and Jerry's near here?
Waterbury, I guess.
Oh, duh, right.
Alright, I was
Can you
killing.
make it a little bigger?
Yes, sir. Okay. Draft 2.1, 328. First change, common interest community resources, section 1, adding a section 3 VSA 119. This is, if you recall from our conversation last week, there was a bill that was introduced, required the state treasurer to contract with a nonprofit for the creation of a common interest community resource center.
Secretary of State.
Oh, I'm sorry, who did I say? Did I say?
Treasurer.
The Secretary of State to contract with a nonprofit.
If it's Tuesday, it must be.
Center.
Yes, okay.
And that was then kind of pared down a little bit to have them provide the information on a free online website. And then I mentioned last time that we had discussed, I had shared that information with the Secretary of State, but they hadn't yet provided any feedback. So they provided some feedback, I think, to you all as a committee, but it came to me. And then I further narrowed down the language to what you have here on the page. I will comment that at this point in time, I don't really know what the language on the page is really intended for. Because I think it probably is just as easy to have the Secretary of State's office commit to doing this on the record, as opposed to taking up a specific statutory section for this language. Because it does simply say that they will provide information to the public, and the information shall include the governing statutes. Governing statutes are already published, they're published on our website, and so there, a lot of the substance of what was going to be provided has been removed. So I'm not telling you you can't have this. If you think that it's important to specifically call this out and feel that it needs to be in statute to ensure that the Secretary of State does this, there's something prohibiting you from doing so. I'm simply making sure you all are aware that I generally wouldn't advise having something so high level in the statutory section, because I think it's probably just as easy to have their verbal agreement to accomplish what you're trying to accomplish, but I understand that there may be reasons that you want this, and so.
Me, right? No, I'm gonna level with the committee and, oh, let's see what you guys think. So Cameron and I talked about this previously, and here's my thoughts, but I'm not a lawyer and I'll go with however the committee feels. This started for myself and Rep. Torrey, how you say it, and a couple other folks who had this request from constituents. I personally like having it there so that people can then see it in our bill, know that we did it, gets it a little more, I don't know. And then, but what happened was the language that Cameron originally had was. What he put was to create a website. So as you'll recall, they aren't creating a new website for this. That's not the right language. What I like about the language, while it does seem very lean and vague, and you know, it basically has them keep the accountability to keep updating it, to have it somewhere. But the language is vague, whereas it could be like they end up just having, we talked about this, a link on their website to the statute somewhere else, right? Like it may not even be on their we don't know because it's that vague. So I won't cry in a corner if people just want to not have it in there and they seem like they'll do it anyway. But it wasn't really a commitment on record. They didn't make the suggestion that you did saying, why do we even need this? So they're not mad about it. So I don't see the harm of having it in there, but you're a lawyer and your advisement was that it seems maybe unusual to have something this vague in a statute. And that may be the case. So what are people's thoughts also? Like, we don't need to spend a lot of time on this. Tom, whoever, what do you think?
Is to leave it in there because this is what I see in the value of it.
Okay,
We get the chance to talk about it for hours and hours. If somebody has a question, and they don't know where to find the answer, even if they go to the page and the first words they see are, it depends. Is it a condominium? Is it a manufactured home park? Is it a HOA? When, and the next set of questions are, when was it formed? Then it takes you to a couple of resources. That would take me, not having had
right.
the advantage of these conversations, that would take me weeks to try to figure out with no direction. So there is value even in just doing that.
Yeah,
You know, so I think that
I don't see the harm, but I'm not in charge.
Others, I guess my feeling is, I would actually add to the. I definitely think it's worthwhile having it there. There's no harm in it. They've committed to it. It memorializes the commitment. They didn't want us to say on their website because what happens, it was a fairly lame reason, maybe,
websites will be obsolete.
but it'll be obsolete, will help. So will I. I think that it could say the Secretary of State shall provide information on their website or otherwise disseminate to the public.
Right.
And that would give them the discretion on how they do it.
Am I mistaken in my memory in that one of the concerns was the information that they have, and so they said public information? I think I don't know why that stuck out in my head. It was in that it was something, I thought she had mentioned as opposed to information to the public, it's whatever public information, not specific to each community because they're all different. And which it's just to extend on that, but just to clean that up a little, I think that was the request, was to say public information, because that way it's not, when they don't have the answers, they can say, it's there, but it's the information that is the generalized information. I thought that was what she said, but I may be mistaken on that.
Right, I think that it was like this wording might sound a little too much like still a call center.
Well, it was their language.
They said this was okay.
Oh, I thought,
Yeah.
I thought
Right,
that
Cameron?
what you're saying, oh, thank you.
What you see on the screen is
Their
based
What they
on
said.
their written feedback.
Oh, it's like, okay.
But we can deal with that easily enough. They
Yeah.
could easily say the Secretary of State shall provide.
But we
publicly
should send it to them to
available-
make sure.
The Secretary of State shall provide publicly available information
Yeah.
on their website or otherwise disseminate about Vermont's common interest communities. And run that up the flagpole and see if they have problems with that.
Yeah, let's run it up the flagpole.
I mean,
Anyway, I don't really, I'm not like, it is,
Unless it's worth doing, let's
it
do it.
is what
Okay,
it is.
yeah, okay, let's do it. Okay,
No fight left.
all right. Section 2,
But thank you.
yeah,
I said there wouldn't be
yeah, I
anything
want to
more
put a
from
little
me.
more in there.
I know, well, I go.
And I told you, you know.
He did. I said he was done with my
And then
request.
we'll see what they do.
I can't help but think that it definitely feels like this would be a missed opportunity if we don't have some
Right,
help with the like our goal is to make sure that the Secretary of State's office is not considered a stand-in for getting legal advice. But also there should be, I feel like, some indication of some of the questions that might arise or that have arisen, that they get, like some sort of FAQ that at least to mention like, you know, solar panels that, you know,
Well, that's-
what, like,
I
I'm just,
agree,
I'm
but-
just saying like
right.
some indication of like.
They didn't want to
some-
be told what to do.
Yep,
Well,
But
just
we
that-
can tell
but we
them.
can tell them anyway.
We can do
because-
whatever we want.
I don't think, what I'd like them to do, I didn't think they were gonna do, but let's start here. Let's throw in a little more language and start here and see what they do.
Yeah, let's test the waters. Maybe they're
Okay.
listening.
Okay,
Okay,
section 7.
the next.
I mean, I
change-
agree, it should tell them.
I agree.
State law contains the following common provisions that you should know about. Bullet.
But they don't
bullet,
want
but
us designing
they
the
don't wanna
web
do
page,
that, right.
because then what they didn't want to what did she say to me? She didn't want to over promise and under deliver.
Yeah, let's see if they under.
Which I get.
Deliver.
It's what they say, lean office.
Okay, next.
Okay, so.
Thank
we
you.
go
We've already
to
spent a lot of time.
section
I said I
Piece
didn't
of
need
shit.
to.
Okay,
Page 4, we're talking about service supported housing and the service supported housing advisory council.
yeah,
So when we get to page 4, you all remember there was some discussion. Primarily, Representative Burrows wanting to make sure that you're very clear about what individuals you're trying to serve here. And as part of the recommendations for future action, that has to be included in the report, the annual report from this council, making sure you're targeted in the population that you're trying to serve. Subsequent from that conversation, I received some feedback from Kristen Murphy directly about trying to ensure that the language is right. And this is what she recommended, was just to reference back to the language that's used above in the section. So this is about creating housing needed by individuals who are eligible to receive Medicaid-funded developmental disability services. So this is the recommendation from the individual who was on the study group that you all created that ultimately resulted in a recommendation of creating this council. This is kind of one of the experts in the area. So I kind of deferred to that person, inserted their recommendation here. If you have potential tweaks about the language to get it exactly how you want, I would potentially recommend having that witness back. And then, with the expert, you nuance on the language specifically and let us know what.
I think this is, my own feeling is this is great. Everybody okay with this for the moment? Remember, we're not voting, we're just for this draft.
Okay, the next piece is in the initial report. This is section 2A. This is where you're asking them in that initial report to come back with a potential per acre surcharge on lands that are in the use value appraisal program. And we're trying to make sure that they're only looking at lands that are utilized as a second home that are in the use value appraisal program. So that's the change there on lines 10 and 11. So it would be implementing a per surcharge on lands enrolled in the use value appraisal program that include a dwelling used as a secondary home. It's pretty just plain language, because in talking with Kirby Keaton in our office who covers, tax areas, he said I would just be plain language, keep it flexible for them so they can look at it.
I would request that you speak with Danny, Fisco.
I will send this.
I ran into her and I heard from a member of her staff that they have some issues. I don't know though, they haven't seen this language,
No, sir.
but I think that I promised Danny that you would be in touch.
Sure.
She's really great. I think that, there might be various hidden problems that we don't know about, and she's a good place to start. I also think I just want to tell members of the committee, I will talk to David Durfee about this because there may be some issues for agriculture in here that we don't know about. I mean, it's just a study, but
That was gonna be one of my comments to you
Yeah.
and potentially to the ag committee, et cetera. You know, at this stage, it's just asking them to look at this and include some information in the
Yeah.
report. So I wouldn't get super hung up on making sure it's as technically, narrowly designed as you potentially need it to be. If they came back with a recommendation that you wanted to move forward with, then obviously you would want to get their
and the
attention.
national,
But
there's other committees that will want to hear it. But the reason that I want you to talk to Jamie is ideally, I would like to get to the point where Danny can inform the administration that they don't have a problem with this study.
okay. I will send that over as soon as we wrap.
I mean, if you can't get there, I don't want to do it, but let's see. Okay.
Let's see. Okay, so the next page is gonna go all the way down to page 15.
Can I just like a very basic, sorry, I feel like I missed, how did this, if this language is just about Medicaid funded developmental disability services housing,
It's about creating funding for that.
it's a tax on a second, okay,
It's a potential surcharge on lands that would be used to generate funds that would be used for
for the
disability
benefit of
housing.
the housing,
Right.
okay, okay.
Okay,
Okay, so we're gonna go to page 15. This is the farm worker housing report, and I've simply made the alterations that were requested by VHCB to make sure that it is a written report updating you on the progress made toward meeting the goals identified in that report, so they're not having to do the report again. And then change from, I think it was on farm housing to farm work.
okay.
Changes there. Next change is going to be on page 18 and 19, and this is where I have added in the section to amend the fiscal year 24 appropriation to VHCD to add in that of the $10 million allocated here, expanding what it can be used for. So currently it's support and enhanced capacity for emergency shelter and permanent homes for those experiencing homelessness. And then it's adding in here or who need supportive housing. And then separately including the same language about funds shall be used to create housing for individuals eligible to receive Medicaid funded developmental disability services.
For the committee, I'm reminding you, this came to us, we have testimony on this. This came to us from not VHCB, but the disability advocates. And then, yes, also VHCB, because as I understand it, they were not, for various reasons, able to spend all the money on shelters and have some left over, and they have disability projects ready to go and could use the money for that. I asked them to check with Teresa Wood, and she was very favorable. The course of this, how we do this, I confess, let's say we leave this in, and let's say we pass this bill. This bill will then go both to Ways and Means and to, most importantly here, appropriations. I don't know what appropriations does because they don't have a budget. You know, I just don't know, but the whole point is it's a signal to the Senate. Because the Senate has the budget. And which will come back to us, so don't ask me exactly how this works, I don't know, I just know it works. I just don't know how it works.
Yeah, I believe the appropriations committee is aware or is going to be made aware of the same, language and agreed if you put it in, it goes to House approach. I presume that they would remove it because as you mentioned, they don't have to. They could leave it in. It could be a standalone amendment to FY 24's budget, but
Yes,
I'm confused.
you too, but
The money has already been appropriated.
correct.
The HCB already has that money.
correct, they just can't use it.
So we're giving them a new purpose that they can also use it towards, is that?
So what happens is you've appropriated the money.
Correct.
If they haven't spent all of it, they can ask for it to be carried forward into additional fiscal years.
Okay.
So presumably, because they're asking for this, they still have some of this money left that they have requested carry forward to continue to spend.
Mhm.
So what this amendment would do is it's going back and amending that one-time appropriation language in the FY 24 big bill.
Yep.
To authorize it to now be expended for these additional purposes.
So then would it go into FY 27's bill?
If,
Big bill?
if they've asked for that money to be carried over, then in this change was included either in this bill or put into the budget, either or, then it would expand. It can live in this bill. It's just amending an act that was previously passed. You all, as you know, the appropriations committees typically strip those things out and put them all consolidated into either the BAA or the budget. So the appropriations committee could take this out and it could just become part of the budget conversation between the Senate and the House as they're doing, their conference committee negotiations and ultimately make it in the budget. Or.
In other
they
words,
put
the
it
27 budget could contain language.
Could contain this exact.
Contain language amending the 24 budget,
Wow.
all right? Live and learn, does that answer your question by any means?
It just seems silly. Oh, yeah, that's fine.
There's a
Like
lot
we
of
should have
things.
put it in
doesn't
the
seem any
27
sillier
budget to be.
to me.
No, I just think that, I don't know, maybe it's just my brain works. It's already been appropriated.
Yeah,
Why can't we just tell the HEB, yep, we're good with it?
this
So
is how
this
we
bill,
tell them.
well, I
Yeah,
know.
otherwise what? They would have to return it.
It sits there, it's $2 million
Yeah.
out of the 10, it's just sitting there.
Is it
I
sitting
don't
Okay.
know how much they have left.
All right. At this point, go ahead, please.
If it was for the same exact purpose as originally allocated, would it then still need to go through this?
We would have been.
That makes sense.
We wouldn't be here.
Yeah, the
Okay.
only reason you're amending it is because you're expanding the statutory authorization for what they can use the money for.
Yeah.
And because it was appropriated in 24, you have to go back to the appropriating language to make the change there.
Yeah.
Because the budget
Unless we created
allocates
a new
money
program.
and tells people what they can spend it for.
Mhm.
So where we are is at this point,
And then it's got just.
we do not have. Right, I'm getting there.
Okay.
At this point, this draft just sits here. Elizabeth is down in the Senate. I just want to say. Elizabeth wanted us to at least discuss. A universal design amendment, which would find its way into here. And at her request. Cameron prepared a draft. And I think even though she's not here, it would be fine to just put it up, Cameron, so that people can see. It's pretty straightforward what
It's
it is.
really clear, yeah. It's good language.
Yes, Dave.
It's the 802 Harms stuff.
No, it's actually, yes,
Partially.
partially, yes.
Okay, so.
But I have, before you go ahead, I have had conversations because I asked people, I asked the person, Chris
Yeah.
people who work on 82 homes. I asked, Chris Cochran, but also, who testified this morning?
Commissioner Farrell.
Commissioner Farrell about it, but the problem was they couldn't open it. So it's, they don't know what they think yet,
But we
but
can,
I,
we
there's,
can just look
yeah,
at.
we can look at it, yeah.
Okay, so draft 1.2, and there's just this language for S328, because I drafted it up in the same way that I drafted up some previous language that you ultimately have in this amendment. As you can see, the first piece would really be an amendment to section 4, which is the offsite construction accelerator pilot program. And so what you have, all of these are highlighted because I'm adding in a section 2. So because I added in a section 2, I had to move up and add a section 1 and then bump everything kind of down the line to the uppercase letters there. So there's no changes in the B1A. So it's really the subdivision 2 here. So it's saying that under this pilot program, housing units funded through the pilot program shall incorporate universal design elements to ensure accessibility to the greatest extent possible to all individuals, regardless of their age, size, ability, or disability. And so if you recall, right, it's the pilot program working with municipalities. The treasurer's office can use some of the money through the credit facility changes that you all made in 775. So if housing units were to be purchased, they would have to incorporate universal design elements. And then you get to page 2 towards the bottom here. This is the report. On or before November 15th, 2029. The agency has to submit the report to you all. The report has to include certain information, and there in line 17, information on whether to enact statewide building code or codes for offsite construction, including whether to enact building code elements related to universal design.
So that's the
pilot, but then you have this language here on page 3, which, as you can see, is just listed as a section X because, depending on where it would be located. It says that this would be session law language as part of its efforts to develop the Homes for All 802 Homes catalog. That's I took that phrasing from their website. I would defer to the department of whether it needs to be, tweaked. I don't know their formal naming of what this catalog is, but that's my understanding from the information on their webpage. The Department of Housing and Community Development shall incorporate universal design elements into each draft home design to ensure accessibility to the greatest extent possible to individuals regardless of their age, size, ability, or disability. So
just for the benefit of people, so Elizabeth really wanted to put this forward to discuss it, not necessarily not to enact something, but just to discuss it. Alex Farrell didn't have an opinion because he hadn't seen the language. Chris Cochran couldn't see the language, but he did this morning here come by and tell me that all of the 802 homes in the catalog utilize universal design. But I don't know what that means. He did say, at this point, we have to find developers who are willing to try them out. They're just designs at this point. The 802 homes thing hasn't moved to the point where
They haven't built them.
they haven't built anything yet, and they haven't got, the pilot towns haven't enacted the zoning ordinances. But remember, there's 3 pilot towns. They haven't enacted the zoning ordinances yet. So it's pretty preliminary. He just said it's in all the design. Tom, and then yes.
The only question I have, it's not complex, so I have 2 questions. One, have we specified it anywhere in statute, we're putting this in statute, what elements of universal design are we asking architects to,
No,
because how are they gonna,
Could be anything.
so that would be something we need to know first.
I think that's, when Elizabeth is here, it's a good question to ask. I do remember that in our housing bill last year, when it came to the,
Be hip.
no, when it came finally, the issue was one of the issues at the Senate House Conference Committee. And at that committee, it was asserted by a number of people on the committee, not me, that remember, there was a universal design study. I can't find it, and the universal design study with a committee, the whole thing. And there were a number of people who asserted that it was the Department of Fire Safety was already engaged in this effort, and this was duplicative of it. And without knowing for certain that that was the case, we talked about talking to those people, and it didn't resolve itself. It came out. It just came out. It was one of those things that just we weren't going to have a fight over, and we took it out. You know how that is in conference. We had other things to fight about, as you may remember. It was not a boring conference committee. So it isn't. I think that's a good question, and I think you should raise it.
So I think I was next. Yes.
Yes, you are next.
I think that our conversations, if I'm misremembering, I feel like Chris Cochran, when asked, is Universal Design Incorporated, there was a discussion that at least two, I think, of the designs are accessible. The first floor units are accessible units and designed to be so, but not all of the homes are accessible.
Correct.
And that definition is a lot more,
Rigorous.
challenging.
Yeah.
Yeah, it's a much more rigorous standard for like rollability and, like stability and flooring and the right thresholds not having too much of like a thick, like lip between door, one floor surface to another, et cetera. But that universal design incorporates much more, much easier to integrate elements that are, I don't wanna, assume, name things in case they're not even, but the point is that I think this language is like whether to include, whether to enact building codes or it's to the greatest extent possible, I think gives a good amount of leeway while still calling attention to like, this is an important policy goal for if you're going to design housing that's going to be infill housing for the future of Vermont to replace old houses that are not retrofittable very easily or cheaply. So there's my
Yes,
position.
or Saudia,
Yeah,
and then Gail.
yeah, I was just, I just said basically what I was gonna say, but, essentially, universal design has to do with it means things, but it says universal, it means accessible to any. And so that means the wider doorways, thresholds, lower countertops, easy accessibility, which is easier to implement than accessible housing. You should, already said what I was gonna say, you stole my thunder. So, but, and I think even though, what did you say, said that it is included in the 802?
Chris Cochran.
Yeah, he did say that a couple of the units.
There's a couple of the
definitely
units, exactly.
accessible.
Are accessible. And so, and I think the language is loose enough that it is not, it says elements of. And that can be up for discussion, which, I mean, like, I think Elizabeth needs to be part of the conversation as to which aspect, if we want to even name that. And universal design has its own definition. So I don't really think that if we need to design that, or if we need to define that, or if we're going with standard universal design, because it has its own definition of what that means. But that's. If folks are saying that it already has it in it, then I don't see why the language is problematic.
Gail and then Tom.
I think Sadia might have answered some of my question because I was thinking, isn't there a definition, a specific definition of universal design? And doesn't the ADA have a specific definition of accessibility? And
Yeah, there's accessibility, visitability, all the different things. I didn't mean to cut you off, I'm so sorry.
no, that's okay.
So if it's accessible, it already meets universal design.
Yeah.
When a universal design is building it the first time so that it is very easily adaptable, future-proof, if you will, and largely it's an aging in place. A kind of question. What I'm. Okay. So I have two sets of questions. I have a couple. I mean, one I've already mentioned. One is, are we talking about voice activated light controls? Are we talking about, I mean, do the numbers on the microwave need to be 4 inches high for visually impaired? I mean, there's all kinds of things that can be, wrapped up in this. So we need a very specific list to give builders before they can tell us, is it a cost driver? Is it not? In theory, it's not. But if you put 36-inch doors in, they are more expensive than 32-inch doors. If you are building 50 houses and every door is 36 inches wide, it's a little bit, it's not zero. So I would look at something in line, a specific list. Before putting it in statute. And two, the financial effect has to be de minimis, and I will keep jumping on this. If we're shaving here, we're shaving interest there, and we're shaving bulk order discounts here, and we're trying to get the price of this down where people can get into it, and everybody's lined up, so to speak, exaggerating, but well, it should incorporate this, should incorporate that, it should be this way, it should be that way. We're going to lose the savings advantage to everything but housing, and then we've gained nothing. So those are my criteria that will make me more comfortable. One is knowing exactly what are we talking about. We're just talking about ramped thresholds, 36-inch doors, lower counters. Yeah, I don't know if you've ever washed dishes at a counter that's too low, but it'll kill your back. Right, it will kill your back in no time. So it's not as simple as just making full counters.
Can I just ask you a question? So are you saying, because I can't even see how financially it would make any sense to make even the doors accessible in anything that you're building. But what you were saying is make it so that the builders
So
could
there's-
easily,
Yes.
I don't know what the word would be.
So when you frame the wall, you put pieces of wood in the wall that later you can attach grab bars to.
Right, if someone was,
So, because it's easier than tearing the door open later. I think it's less expensive to put a 36-inch door in than it is to frame for a 36-inch door and then frame inside that for a
Right.
32-inch door. Just do it first time is probably less labor cost.
Well, I think the
So there's, it makes
accessible is
sense.
the
And
key
but
word.
what I need to hear a builder say, yeah, that won't cost anything different, or it's very, for
Minimal.
what it achieves, it is minimal. So I can't find the report. It's maybe in the report and I just can't locate it.
Yeah, this is not a world, but yes, go ahead.
So I have a few questions. And I think it might be good to consider tabling this conversation until Rep Rose is back,
Sure.
because I am 98% sure part of why this has continuously come up is that we actually don't have a definition of universal design. I am very confident of that. But I could totally be wrong and would love to be proven wrong. And so I would like us to consider tabling this without her for it now, or until she returns. But 802 Homes catalog. It's my understanding that all of the homes, like the catalog, the draft designs, they're already completed.
Yes. and
No,
Chris
because they're taking
Cochran-
a lot of feedback. They're doing all these
Yeah.
feedback days.
Yeah, but the draft,
Designs.
there's a draft, all the draft designs and the draft, what do you call it, drawings are done.
Yeah,
And then they're trying to get developers and trying to try them out. And then they'll be revised.
I don't think we're necessarily locked into 802 homes. We just have a resource there where we've eliminated the soft costs of
Right.
engineering and architecture, but that doesn't mean another manufacturer doesn't have their own designs eligible. And they need to know what the criteria are if they're gonna submit a request for proposals.
Debbie?
Well, it's kind of silly, but even, I mean, people that they can have a medical condition where they're like very tall. There's a genetic component to that, and they're disabled because of not because of their height, but because of this genetic factor.
MR fans, yeah.
And I mean, then they don't want a low cabinet or a countertop, they're gonna need a higher one. So, I mean,
It's
so,
dealt with, I'm sure people have thought of this, I just don't know how they've dealt with it.
it was just a
and
wrench.
it's not all of it, it's gotta be
It's
lower.
generally,
Yeah.
all I know
Yeah,
is that
it's not-
generally universal design, as Tom said, is not that the thing is necessarily installed, but that the house is prepared so that it can be installed.
Yeah.
But
Yeah.
how you apply that to, I don't know. Fine, I agree with the tabling, but you get to talk one more time.
Are we talking about built-in homes or is this apartments? This is any dwelling
And
whatsoever?
it's any dwelling, but and I do have personally, I do agree with Tom that I don't want to see the pilot program stymied unnecessarily. It's important. But I also feel like it would be really great. In fact, everybody ought to think about it. Just keep it in the back of your head. Is there something we can do? Something we can say if Ashley's right, and there isn't a unified definition, and if we're not going to get what Tom wants now, well, your list, and we're not going to do that now, is there still something we can do and something we can say? Just think about it, and we'll talk about it when Rep Burrows is here, okay? And we'll calendar that, okay? I'm sure you're all going to be disappointed to hear that at this point, what we're going to do next is have a 9:30 a.m. visit to Huntington Homes. So I just want to go back. I am prepared to come in and be here to drive anyone who's here to Huntington Homes. Joe has alleged that he is willing to do that, although Joe told me that he didn't want to go to Huntington Homes any more than I would want to go to a field trip to a law firm.
So I'm not riding with them. is what
But at
I'm-
any rate, I will come here and I will make sure we have enough. But some of you are going directly, Debbie, you're going direct.
Yeah, I'm picking up Krasno and going
Okay,
direct.
directly, okay, so.
Well, if we're not there, start without us.
I think it will be interesting for everybody to see how these places are built. I have asked, just so you know, not that anything is gonna come of it. I have asked whether we have access to money for a 2-day trip. Because what I would really like to do is to go to one of these manufactured home factories. I want to see the factory where they produce 1,000 of these homes a year and talk to people about how they can do it for so little money.
In
But they're
Pennsylvania.
all, a bunch of them are in Philadelphia, in Pennsylvania, and others are in Quebec, and I just would have to see how we would get there and if it's worth it.
I know about Champion Homes in New York, because they're the ones that are building the Crossmont, New York. On
Champion Homes in New York, do you have any idea where they are?
Yeah.
Yeah, okay. We also are planning a possible trip to see a mobile home park, excuse me, a manufactured home park.
A limited equity.
An unlimited equity
cooperative
mobile home park.
Manufactured
So
community.
that's 3
Field trips?
field trips.
Now, the other, I don't think we're gonna do a 2-day field trip on that. I don't think it's gonna happen. I don't know if we can calendar it.
As someone who is very passionate about housing, I am even more passionate about
Your children.
saving taxpayer money. And would feel a little bit uncomfortable with a 2-day trip.
Okay, well, it has happened. And we could all pay for ourselves, of course. All right,
Where has it happened, a 2-day trip? It never,
really?
yeah, must be appropriations. That's where the money is.
Okay, anything else before we adjourn? I'll be here in the morning. For anybody who needs a ride, I could really take 4 people, so.